A lot of people assume that if someone dies without a will, everything will just pass to the right people automatically. But in practice, I often see situations where the outcome is very different to what the family expected, and sometimes quite difficult as a result. I'm a solicitor working in probate and estate administration in England and Wales, and one of the most common issues I deal with is estates where there is no will. So in this video, I'm going to explain clearly and practically who inherits when there is no will, how the intestacy rules actually work, and the situations where people are most often caught off guard. And if you're dealing with an estate at the moment, I'll keep this as clear and practical as possible. If someone dies without a valid will, they are said to have died intestate. At that point, their estate doesn't get distributed based on what feels fair. It follows a fixed set of legal rules. There's no discretion in those rules, and the person's wishes, if they were never formally recorded, aren't taken into account. The first person considered is the spouse or civil partner, but what they receive depends on whether there are children. If there are no children, the spouse will usually inherit the entire estate. If there are children, the position becomes more structured and sometimes more complicated. Where there is both a spouse and children, the estate is divided in a very specific way. The spouse receives all personal belongings, a fixed sum, currently £322,000, and half of anything above that. The children inherit the remaining half. This can lead to situations where the family home or assets are effectively shared between the spouse and children. If there is no spouse or civil partner, the estate passes down a strict order. Children inherit first. If there are no children, it passes to parents, then siblings, and then more distant relatives. This is one of the most important points. Unmarried partners do not automatically inherit under the intestacy rules, even if they've lived together for many years. For example, I've seen situations where a couple have lived together for many years but never married. The house is in one person's sole name. If that person passes away without a will, the surviving partner may receive nothing under the intestacy rules. Instead, the estate may pass to children or other relatives. Stepchildren are also not automatically included unless they have been legally adopted. So again, the outcome may not reflect what the family expects. The common scenario is a blended family, where someone has stepchildren but no biological children. If they die without a will and haven't formally adopted those children, the stepchildren may not inherit anything. Instead, the estate may pass to other relatives. If there are no eligible relatives, the estate can pass to the Crown. This is rare, but it does happen. In some cases, there are no close relatives, and the estate ends up being traced through distant family members. This can significantly delay the process and create uncertainty. The reason this causes problems is because people often assume the law reflects what feels fair. But intestacy rules don't work that way. They follow a strict legal structure, which doesn't always match modern family situations. The simplest way to avoid these issues is to have a valid will in place. Make sure you review your will every 12 months to make sure it still reflects your wishes. That allows you to decide exactly what happens to your estate. If you have a complex family, for example, an unmarried partner and children, then I would recommend that you get legal advice about your estate and will to avoid problems in the future. So the key takeaway is this. If there is no will, the estate is distributed according to strict legal rules, and those rules don't always reflect what someone might have wanted. If you're dealing with an estate at the moment, having a clear structure makes everything much easier. I've put together a free Executors Checklist that walks you through everything step by step. You can download it using the link in the description. And if you'd like clear, practical guidance on probate in England and Wales, feel free to subscribe.